I want to start with the number because the number is the thing that, when I tell this story in person, causes people to stop and ask me to repeat it. $12. The original fine that Sheila Doss, the president of the Birchwood Glen Homeowners Association, had convinced her board to place on my property as a formal lien was $12. It had started as a single $12 administrative fee for what the board characterized as an unapproved exterior modification, which was a small ceramic planter I had placed on my front step, approximately 10 inches tall, containing a potted fern, which I had owned since before I moved to Birchwood Glen, and which had sat on front steps of 3 previous homes without anyone in any community noticing it, caring about it, or finding it worth the administrative infrastructure of a formal lien. But Sheila Doss noticed it. Sheila Doss cared about it, and Sheila Doss, for reasons I will explain in detail because they are important for understanding everything that followed, decided that the correct response to a ceramic planter and a fern was a legal instrument attached to the title of my home. The fine accrued penalties. This is what HOA fines do when they are not paid, and I had not paid the $12 fine because I had not received the original notice, a detail that would later become one of the more significant pieces of documentation in this story. The notice had apparently been mailed to an old address the HOA had on file rather than the property address itself, an administrative failure that I discovered only when I received a letter from a title company 6 months after the fine had first been issued, informing me that a lien had been placed against my property for an unpaid HOA debt of $234, which was the $12 original fine plus $180 in accumulated late penalties, plus $42 in administrative processing fees that the HOA charged for the act of placing the lien itself. I want to sit with that for a moment. A $12 fine I had never received notice of had, through the power of automatic penalty accrual and administrative fees, become $234 on a lien attached to my home's title, and I had learned about this not from the HOA, but from a title company conducting a routine search for an unrelated refinancing application I'd submitted, the outcome of which had now been complicated by a title encumbrance I hadn't known existed. I called the HOA's management office. The woman who answered transferred me to Sheila Doss directly, which surprised me since I'd expected a property manager rather than the board president, but Sheila apparently handled calls of this nature herself, which tells you something about the degree to which the HOA's operations had become, over time, a personal project of hers. She was brisk, informed, and entirely untroubled by my confusion. She confirmed the lien, confirmed the amount, confirmed that it had been escalating since the original notice had gone unpaid, and when I explained that I had never received the original notice, she told me, in the specific tone of someone who has made peace with being technically accurate rather than actually fair, that the notice had been sent to the address on file and that the HOA was not responsible for delivery failures if the member had not kept their contact information current. The address on file was my previous address, I said. The property address is the same as the Lien address. It's the house. You could have mailed it to the house. Members are responsible for keeping their contact information current, Sheila said, and then she told me the fine had to be paid in full before the lien would be released, and that the refinancing I'd mentioned would be blocked until it was. She said this last part with a particular calmness that told me it was not an oversight or a regretted side effect. It was the point. My name is Wendell Okafor. I'm 46. I work as a commercial real estate analyst, which means I spend a significant portion of my professional life reading legal documents related to property ownership, debt instruments, encumbrances, and the specific mechanisms by which property rights are transferred, restricted, and defended. It is not a coincidence that what I eventually did to Sheila Doss's situation was something I understood mechanically before I understood it emotionally, which is to say, I recognized the legal structure of the solution before I fully appreciated how perfectly it fit the situation. I moved to Birchwood Glen 2 years before this story takes place, buying a 4-bedroom colonial on Pembroke Court that I've spent those 2 years fixing up gradually, the way you do when a house has good bones but needs attention. I am a meticulous homeowner. I have never received an HOA violation in my life before or since this incident, not because I'm unaware of the rules, but because compliance with property standards has always been something I genuinely cared about independent of whether anyone was watching. The planter, which Sheila had cited as an unapproved exterior modification, was by any reasonable reading of Birchwood Glen's governing documents not a structure, not a permanent installation, not anything other than a decorative item placed temporarily on a front step. The kind of thing that appears on the front steps of roughly 40% of homes in any suburban neighborhood, and which I would defy anyone to find specifically prohibited in any HOA governing document written with even minimal care for proportionality. The planter had been there for 2 weeks when the notice was allegedly mailed. I had never seen the notice. The lien appeared on my title 6 months later and blocked my refinancing, which at current interest rates was a decision with real financial consequences, because the refinance application I'd submitted was going to lower my monthly payment by a meaningful amount that I had specifically wanted to redirect toward my children's college accounts. I paid the $234. I paid it immediately by certified check because I needed the lien released to continue with my refinancing, and I did not have the time to dispute it through proper channels while rates were moving in the wrong direction. But I kept every piece of documentation. The certified check copy, the lien release document, the records I'd subsequently obtained from the HOA's management company through a formal records request showing the original notice had been mailed to an address that was not my property, and the full governing document package, which I read carefully and completely over the weekend after the lien was released, the way I read any legal document when I've realized it contains something I need to understand fully. What I found in those governing documents, and what happened over the following 3 months as I began paying closer attention to how Birchwood Glen's HOA was actually operating, is where this story turns from a frustrating bureaucratic experience into something considerably more interesting. Birchwood Glen's HOA, I discovered, had a specific provision in its governing documents regarding fines and their accrual, a provision that required, before any fine could be assessed for a first violation of any aesthetic provision, a personal notice to the member, either delivered in person or sent to the property address, followed by a 14-day cure period during which the member had the right to correct the cited issue before any financial penalty was applied. The notice was required to be specifically directed to the property, not merely to whatever address the member had on file for other correspondence, because the violation was property-specific, and the cure period assumed the member could actually observe the cited condition. This provision had not been followed in my case. The notice had been sent to an old address. I'd never received it. There had been no 14-day cure period because I hadn't known a fine existed to trigger one. The fine had been assessed and had been accruing penalties for 6 months before I learned it existed, all in direct violation of the HOA's own procedural requirement. Elena Farris, the property attorney I consulted the following week after reading the governing documents, confirmed what I'd suspected and added something I hadn't fully worked out on my own. The lien was procedurally invalid when it was placed, she told me, reviewing the document sequence. The notice requirement in your CC and RS is a mandatory prerequisite to fine assessment, not a courtesy step. Assessing fines and placing a lien without following that procedure made the original debt itself challengeable. You paid a debt that you likely could have successfully contested, which means you're out $234 you didn't legally owe. I told her I knew that, and that I'd paid it to clear the refinancing rather than to concede the point. That's sensible, she said, but it means if you want recovery for the wrongful lien, you have a civil claim for the amount paid plus any demonstrable costs from the refinancing disruption. She paused. Do you want to pursue that? I want to understand the full landscape first, I said, the way I say it at work when I'm not ready to commit to a strategy, but I'm gathering the information I'll need to. Tell me about HOA debt structure. How do these fines and liens actually work from a debt instrument perspective? What Alina explained over the following 30 minutes was information I half knew professionally and now, for the first time, had specific reason to apply to a personal situation. HOA fines, once unpaid and liened, become recorded debts against a property title. Those debts, in most states, can be sold by the HOA to a third party, the same way any debt instrument can be sold, and the purchaser of the debt steps into the HOA's shoes in terms of the right to collect. What I did not know, and what Alina confirmed when I asked the specific question that was forming in my mind, was that in our state, HOA debt purchasers had the same legal standing as the HOA itself, including, under certain conditions, the right to pursue collection actions up to and including foreclosure on a property carrying the liened debt. Can individuals purchase HOA debt? I asked. Alina looked at me for a moment. You can purchase a lot of things if the seller is willing, she said carefully. HOA debts are occasionally sold in bulk to collection agencies. Individual purchase of a single debt is less common but not inherently prohibited. Why? Because I'm wondering, I said, what Sheila Doss's HOA compliance history looks like. Alina was quiet for a moment. You're wondering if she has unpaid HOA debt, she said. I'm wondering if the president of an HOA that violated its own notice procedures to place a lien on my home has any outstanding fines or liens of her own, I said, which seems like a reasonable thing to know. The answer to that question, which took me about 2 weeks to fully assemble through a combination of public records research that is entirely available to anyone with the time and knowledge to look, and which is where this story goes from interesting to something I think is genuinely remarkable, was not what I expected. It was better. Sheila Doss had 3 unpaid HOA fines on her own property. The oldest was 14 months old. They had not been liened yet, which was itself an irregularity given the HOA's stated fine escalation policy, suggesting that the board's president enjoyed an informal grace period that other residents, like me, apparently did not. The fines totaled, across all 3, approximately $312 in base amounts, and given the HOA's own stated late penalty schedule, which accrued at 15% per month on unpaid assessments, would have been considerably higher if the penalties had been applied consistently. I called Alina and told her what I'd found. She was quiet for a long moment. Then she said, "Walk me through what you're thinking." I walked her through it. The HOA's governing documents allowed the board to sell or assign outstanding member debt obligations to third parties for collection purposes, a provision that existed in a lot of HOA documents as a mechanism for bringing in collection agencies when members went significantly delinquent. What it also meant, as a legal matter, was that the HOA could sell Sheila's debt to a third party, provided the board voted to do so. The board had 5 members. Sheila was the president. The other 4 members were people I now knew the names of from the public HOA minutes I'd obtained through the records request, and 2 of them I'd since learned from conversations with neighbors I'd started having with more intentionality since the Lien incident, had their own histories of tension with Sheila that they'd never had an avenue to act on. "You're thinking about approaching the board about selling Sheila's debt," Alina said. "I'm thinking about approaching 2 specific board members who I have reason to believe would be receptive to a proposal," I said, "about whether the board might be willing to sell certain outstanding member debt obligations to an outside party, at fair value plus a small premium for their administrative convenience, which would be legal, would be within the board's authority, and which I would be the outside party interested in purchasing." Another silence. "And if you owned Sheila Doss's HOA debt," Alina said slowly, working through it, "you would have, as the debt holder, collection rights under the same instruments that the HOA itself would have, including the right to formalize the lien that the board had apparently been declining to place on her property, and to pursue that lien through the collection process available under state law. Which," I said, "in our state, includes foreclosure proceedings for HOA debt that reaches certain thresholds after proper notice." Alina said nothing for several seconds. Then she said, in a voice that was professionally composed, but contained something I recognized as genuine amusement trying to stay behind a neutral door. Wendell, this is either the most elegant thing I've ever been asked to facilitate or the most complicated. I need to think about whether there are any reasons it can't be done before I tell you it can. She called me back in 2 days. There were no reasons it couldn't be done.